Hello, my friends. Today we discuss a very interesting topic. What should one do when they get a notice for arbitration? Whatever you do, please do not ignore it. The arbitration law in India, as around the world, is very strict and at times draconian. So, if an order is passed against you in an arbitral tribunal where you may not have even participated or even not know, that can easily be enforced. You will not even know and what is going to be argued, and it can be very detrimental to you. So my advice would be, if you ever get a notice, usually under section 21 of the Arbitration and Conciliation Act 1996, please immediately consult a legal person who is trained in law, a legal professional, and immediately reply to that notice. Whether you agree to the arbitration process or you do not agree to the arbitration process, participate in the arbitration process. You must participate and defend yourself. There is minimal court interference in arbitration because the Supreme Court has made it very, very clear that the civil courts of this country should not interfere. Personal views aside, even if some of us feel that yes, there should be much more interference because of the kind of arbitration that goes on in this country, but the Supreme Court in its wisdom has thought that no, for business to proceed, it is better that the alternate dispute resolution mechanism, specifically arbitration, should be divorced from any kind of interference by the courts. So it is only at a stage when arbitral awards have been passed that the court can look into it when challenged. But here also, that through recent amendments, the law has been made extremely draconian to challenge even a fraudulent award. Earlier, there used to be a requirement of payment of part of the damages which has been awarded in the arbitral award. But now there is a recent amendment, thankfully I must add, that if you can show fraud, then that is not required to stay the award. But otherwise, in proper arbitral forums, if you do not participate and there is an award passed against you, then what will happen is you will not be able to get a stay of that unless you pay a part of the sum as decided, usually at least 50% of the sum awarded against you. So my advice to everyone who's listening here is that please participate in any kind of arbitral proceeding if you are made a party to the same. Take all your defenses there, that the arbitration should not be there is no arbitration clause, this is a fraudulent arbitration, that there is a pre-existing some other dispute, it has a settled matter, there is no arbitrability of this proceeding, of the disputes. All of these defenses, all the things that you want to say, you have to go and do it before the arbitral tribunal, and you cannot approach a civil court. So my advice will be, my friends, please do not ever ignore a notice for arbitration and immediately consult a legal professional and thereafter participate in the proceedings. Thank you. I hope it is good. This advice serves you and helps you guys. Thank you and have a nice day.